Our next plenary session, Law and Business in South Asia, is brought to you by Prima Group. To discuss the issues of dispute resolution, please welcome your panelists for this morning, Dr. Shirani Bandaranaike, 43rd Chief Justice of Sri Lanka, Mr. Sachin Pilot, member of the Indian National Congress and former Minister of Corporate Affairs, India, Mr. Shardul Shroff, Executive Chairman, Shardul Amarchand Mangaldas, India, Dr. Pinaki Chakraborty, Professor, National Institute of Public Finance and Policy, India, and Mr. Vishwa Sadasivan, Board Member, Singapore International Mediation Center, and Chief Executive Officer, Strategic Moves Singapore. Our chair this morning is Ms. Lim Seok Hui, Chief Executive Officer, Singapore International Arbitration Center and Singapore International Mediation Center, Singapore. I'd like to remind you that when it comes to questions and answers, you have to post your questions using the online Pigeonhole Live. With that, over to you, Ms. Lim.
Thank you. Good morning, everyone. It is my pleasure and privilege to be moderating this eminent panel of speakers on the topic of dispute resolution. Now, we've all been hearing a lot about growth and globalization, but with an increase in cross-border trade, an increase in investments, an increase in M&A activity, all this inevitably will lead to an increase in disputes. What investors and companies doing business in South Asia will need for continued economic growth is a neutral, independent, efficient, and cost-effective dispute resolution mechanism to resolve their commercial disputes. Now, first of all, I'd like to introduce my panel today. At the extreme left, we have Professor Pinaki Chakraborty, Professor of the National Institute of Public Finance and Policy from India. To my immediate right is Mr. Sachin Pilot, whom you've heard from when he gave his speech earlier. To my left is Dr. Shirani Bandaranaike, and next to her is Mr. Shardul Shroff, Executive Chairman of Shardul Amarchand Mangaldas from India. And finally, we have Mr. Vishwa Sadasivan, Board Member of the Singapore International Mediation Center, the SIMC, and CEO of Strategic Moves. So first off today, I'd like to invite Mr. Shardul Shroff to present. He will talk about common types of disputes in M&A deals, the preferred dispute resolution mechanisms for these situations. He will also touch briefly on recent dispute resolution reforms in India, specifically the Arbitration Amendment Act and the Commercial Courts Act, and what impact these reforms will have on the dispute resolution landscape in India. Mr. Shroff, please.
Friends, thank you very much for having me over and speaking on the subject of dispute resolution in the context of the South Asian diaspora. The context of what I'd like to talk is how the dispute resolution framework has been changed in India and what are the kinds of disputes in mergers and acquisitions, which is perhaps the largest scope of cross-border transactions besides international sales. And finally, the issue of some hybrid forms of dispute resolution, which I shall touch only in brief because Vishwa is going to deal with them. So if I may start, what are the kind of disputes that the space of mergers and acquisitions throw up? Typically, in a M&A or a shareholders arrangement, there would be two parties or two groups, and they would select the law which would apply and would typically also have an arbitration agreement. Because the problem of enforcement of judgments and the delays in law courts necessitates that the arbitration forum should be recourse. The types of disputes which are arising in the context of mergers and acquisitions are typically of three types. The pre-closing disputes, which are really relating to certain conditions precedent, which are typically embedded in a shareholders agreement or in a merger, which have to complied with before really the M&A comes into effect. And if a party deliberately drags its feet and is really responsible for those preconditions failing, then a dispute does arise. Issues in relation to non-disclosure or breaches of confidentiality covenants are also quite significant. Most of the companies are also now getting regulated by the Securities Exchange Board of India, and most developed countries are having insider trading regulations. So the concept of confidentiality is very critical in that trade information or information of companies which is disclosed in due diligence does not get spread without really having an opportunity of offering that very same information to members of the public. That which is in the public domain is not confidential. There are certain issues which flow out from the due diligence of a company which is to be acquired, and these relate to forecasts, these relate to differences in accounting methods and taxation. The tax indemnities have become increasingly important because of the kind of judgments that have been rendered, say in the Vodafone case or what is happening currently in the Cairn Energy case in India. There are post-closing disputes which really relate to breaches of representations and warranties and the impact of such breach. Typically, a representation and warranty is supported by an indemnity, and the claim has to be met within the terms of the indemnity. There could be third-party claims also, which really are excluded at times or not taken into consideration in counting the cost of acquisition. There are other kinds of disputes relating to put and call, where the ability to call upon the shares of the counterparty or to sell one's shares by putting those shares on the counterparty are contracted, especially when exit provisions are provided. And there also the question of valuation and price determination become important. So these are the typical frame of disputes which arise in M&A transactions, and these are the disputes which lend themselves to arbitration. Because proving these in a court of law, especially when the commercial judges are really few and far, is important. The dispute resolution permits or provides a faster remedy in comparison to national courts. It is not a universal phenomenon that all states, and there are 29 states of India, have commercial courts or have commercial judges. So these are questions which require an expert panel to decide the disputes. Again, in the forum of a tribunal, confidentiality can be maintained exceedingly well, and it is a matter of party's choice. The procedure is also much more flexible, and it provides for a neutral venue, especially when parties do not want to be subjected to any biased venue. There are two types of arbitration, the ad hoc arbitration and the institutional arbitration. And the process, like for example SIAC, is in the nature of an institutional arbitration. Newer institutions like these are now emerging in India. We're likely to set up the Mumbai International Arbitration Center shortly. There are prior institutional arbitrations already in place, but this is something which is progressing, because an institutional arbitration center provides greater support to the process, sticks and adheres to timelines, is far more credible than ad hoc arbitrations, and also permits the consolidation of multi-party or multi-contract disputes. The process of hybrid arbitration is a mix between arbitration and mediation. If mediation precedes arbitration, the outcome of a mediation could result in a consent award resolving the disputes. Similarly, if a party does not conclude on a mediation, the disputes unresolved could go into an arbitration, and this could be in many forms. I'm going to leave it to Vishwa to speak more on that subject. But it also enables a negotiating margin to parties. What has happened pursuant to the Arbitration and Conciliation Act Amendment of 2015? There are 6 or 7 broad features of that amendment. Initially, the decision or the order of the arbitral tribunal or a foreign court in relation to preservation and providing interim measures was not reciprocally enforceable. It is only a judgment which is enforceable. So to cover this lacunae, the Government of India amended the Act so as to provide that interim reliefs from an arbitral tribunal or interim reliefs even from a foreign court would be enforceable in proceedings, especially since there were measures to protect and preserve the subject matter of the disputes. For the first time, the legislature has played a tremendous forward-looking role in providing guidelines for the conflict of interest of arbitrators. The IBA guidelines on conflict of interest have been embedded in 2 schedules, Schedule 5 and Schedule 7, which really detail out the nature of conflicts which could result in either not permitting the arbitrator to be appointed or examining questions of conflict of interest in a proceeding. The explanation of public policy, which was a vexed question and typically a question which parties used to recourse for setting aside an award, has also been limited by the amendment. And patent illegality is no longer a ground for setting aside public policy. Only 3 grounds, namely inducement by fraud or corruption, contravention of the fundamental policy of Indian law, and conflicts where the award is conflicting the most basic notions of morality or justice, are the 3 grounds available. And it is to be noted that the reopening of a judgment on merits, an award on merits, is no longer permissible in the Indian context, and that saves a lot of the time that has been spent and invested in international arbitration. The previous law in India was that the filing of an appeal was an automatic stay of an arbitral award. This has been changed, and now a separate application has to be filed if an award has to be stayed, and it is akin to a money decree, so the court could ask for a money deposit partially to secure the award. There is also a time limit which has been now prescribed for making an award. The initial time frame is 12 months with an ability to extend for another 6 months. And so the delays in passing awards have also been addressed. The definition of a court has been amended, and in the context of international commercial arbitration, it is only the High Court which has jurisdiction. So approaching a district court or a smaller court which has original jurisdiction has been prevented, and this was the cause of a lot of grief in the prior amended scene. Should I wind up?
So go ahead, wrap up. No. If you'd like to wrap up.
Okay. These amendments to the Arbitration Act are to be seen in the context of the introduction of commercial courts, which are specialized courts created under a separate law, and they are to deal with only commercial disputes and not personal disputes or other disputes which can arise before judges. These judges are expected to have experience in commercial matters and the ability to resolve commercial disputes. Again, a fixed time limit is prescribed for completion of pleadings, filing of documents, inspection of documents, and the case disposal. It's all again in the time frame of 180 days. The judgment has to be pronounced within 90 days and appeals to be filed within 60 days of the judgment. So the process, including the decision time for an appellate division, is restricted to 6 months. So what is the effect of these amendments, both the commercial courts and the arbitration amendments? Specialist judges with expertise are being appointed for dealing with high commercial disputes. It streamlines the process of resolution. The focus is clearly on speedy resolution of disputes within specified timelines, both for the tribunal and for the court. The ability to approach the High Court or a tribunal for interim relief without suffering the lack of jurisdiction question even before the award or after the award is provided. There's a greater credibility to the arbitration process because of discipline around the arbitration fees as also the conflict of interest question. And there's a reduced incentive for filing applications or appeals to set aside awards because of the requirement of a pre-deposit in the court if it is a money decree. Thank you so much.
Thank you, Shraddha. Next, I'd like to invite Dr. Chakraborty, who will tell us what is in store over the next decade for South Asian economies in terms of growth prospects and challenges.
Thank you, Chair. Fellow panelists, distinguished participants, good morning. I'm grateful to Ambassador Gopinath Pillai and ISAS for inviting me for this convention. This is a big honor for me. I have a presentation which actually has 3 components. One is growth in South Asia, the major highlights. And if we look at the latest World Bank Spring Report of 2016, it says that South Asia is the fastest growing region in the world, and it has consolidated its growth position for 2016 and 17 and expects a growth rate around that level for the next couple of years. India remains the motor of the region, trying to achieve 8% growth rate. However, growth remains unequal across countries in South Asia. In other words, it's not a homogeneous block. There are huge diversities, huge challenges across countries. And this growth, if you look at, India is the driver of growth, followed by Bangladesh, Pakistan, and then Nepal rebounds back after the major earthquake last year. Now, what is the focus of my presentation? What does the next decade have in store for South Asian economies? That is the first part. How these countries could grow at a faster pace, economic cost of dispute with special focus on tax disputes, can simplify tax law and system minimize tax dispute and promote growth. That's the issue that I'll highlight. Now, if we look at South Asian economies, growth in an uncertain global economic environment is commendable, but there are fading tailwinds. That's what the World Bank describes it, and these fading tailwinds are declining capital flows to the region in the last 2-3 years, declining remittances from oil exporting countries. Uncertainty persists about the continuance of the benefit of lower commodity prices, particularly oil. Rising oil prices can increase inflation and harden monetary policy stance, further adversely affecting the growth, investment, and business. Now, also, if we look at the South Asia's next 10 years, I think one of the major issues in South Asia is high public debt. And if we look at the world region, South Asia has the highest public debt to GDP ratio and the deficit to GDP ratio to the tune of around 4% of GDP. So large debt servicing cost is reducing fiscal space for increasing fiscal space for development and investment spending. And the debt to GDP ratio is around 65% of GDP. Now, if we look at among these countries, this debt to GDP ratio is driven by India's debt to GDP ratio, which is at around that level of 65 to 66%. Now, if we look at South Asia's entire GDP, India contributes 77% of South Asia's GDP, followed by Pakistan, which is around 10%. Now, if we look at the domestic, since India's GDP is 77% of the South Asia's GDP, resolving domestic policy challenges in India is critical to overall economic growth. And these challenges are, as has been mentioned before, stressed banking sector assets and rising NPAs, stalled investment projects, GST logjam in the upper house of parliament, policy coordination at federal level is not easy, when each state in India is now propagating their own model of development and growth in India. When we are talking about dispute, it is not only the dispute between business and government or across business, globally integrated. It is in a large country like India, it is the interstate and center-state policy coordination challenges and dispute would become a major issue in the years to come. And GST is one of the major, one of the critical examples of that. Now, if we look at the economic cost of dispute, I have tried to look at data across South Asia region, and it's very difficult to get those information. But thanks to the Fiscal Responsibility and Budget Management Act of 2003, fiscal transparency norms in India now requires government to publish revenues locked up under tax dispute. So if we talk about economic cost of dispute, that data for India I could collect from 2005-06 to 2014-15, and this is a huge number. Outstanding tax dispute in India, that is only for the federal government, there's the central government, I'm not talking about 29 states. If we look at the outstanding tax locked up under dispute is to the tune of rupees 7,000 billion in FY, financial year 2014-15. And that works out to be around 49% of the tax revenues collected by Government of India in 2014-15. Now, 80% of the tax disputes are direct tax disputes. It's not the indirect tax dispute. And I think we need to talk about direct tax dispute mechanism in a much more aggressive way rather than the way we have been reforming our direct tax systems. I'm not saying that we haven't reformed. I think we have come a long way in terms of reforming direct tax systems since 1991 to 2014-15. Direct tax revenues have grown at a phenomenal rate from 2003 to 2007-08, and it is again picking up. But I think tax dispute remains a major challenge. And now, if we look at the incremental tax dispute, what has happened in the last 10 years, that means increase in tax dispute, except 2005-06, where there is a negative number, the tax dispute as a percentage of revenue has been around 9 to 10% of the total revenue collected, which is again a very huge number. Both outstanding as well as the incremental tax dispute is a major challenge. Now, when we are talking about globally integrated business and tax dispute, a non-harmonized global tax system is a major challenge for the globally integrated business. And when we are talking about tax harmonization, whether within India or across countries, we always talk about rates. We don't talk about processes. We say we compare 30% income tax rate of India with the emerging market economies, but the tax system and tax processes are very different across countries, and business faces different tax system, different tax administration in different countries, and that is a major challenge. And setting up an efficient and fair tax system is far from simple. And if we look at the factors contributing to tax disputes in South Asia, the literature and the available information that we have, there are few common features. One is complex tax system and laws, selective taxation and distortionary tax regime with a combination of origin-based and destination-based tax system, target-led approach to tax collection, and lack of functional specialization in tax department, inadequate dispute resolution and settlement mechanism in the tax authorities. Now, needed reforms in the tax system we are talking about. We need a non-distortionary consumption tax regime, and we need to implement the broad-based, low-rate approach to tax reform so that we don't have selectivity in taxation. I think this has been done in a great way in India when in 2005 VAT was introduced. Now in the country, we have a single VAT rate, but we still have a separate a separate service tax regime which is taxed by the central government, and we are trying to reform that and having goods and services together with an integrated tax system, with an integrated simplified indirect tax system. Introduction of GST should help simplify the complex domestic trade tax system in India. However, imperfect GST design may provide suboptimal outcome. And the GST, as you know, is stuck in the upper house of parliament. And one of the contentious issues in GST design is the structure of post-GST dispute settlement mechanism. If we look at our 2011 GST bill, it has talked about a dispute settlement mechanism to be set up, but the present bill, the 122nd Constitution Amendment Bill of GST, talks about settlement through consensus. So we have business, we have 29 states, we have the federal government, and we need to have a proper dispute settlement mechanism within the GST regime. So in order to conclude, a positive outcome for GST, I think these issues need to be resolved so that we have a simplified tax regime for business and growth. Now, to conclude, though uneven across country, South Asia has consolidated its growth position in an uncertain global economic environment. Sustaining this growth requires addressing many domestic challenges, including speedy dispute resolution for globally integrated business. Sustained economic growth in South Asia is also going to increase cross-border commercial activity, which would invariably lead to increase in dispute among the stakeholders. In this context, it would be appropriate to have alternative dispute resolution mechanism which is independent, neutral, efficient, and cost-effective, such as arbitration, mediation, or a hybrid mechanism. Thank you very much.
Thank you, Pinaki. Our final speaker will be Mr. Vishwa Sadasivan. Now, you heard earlier from our Senior Minister of State for Law and Finance about the steps Singapore is taking to develop itself as a dispute resolution hub in Asia. And she talked about the two new ADR offerings, the Singapore International Commercial Court, the SICC, and the Singapore International Mediation Center, the SIMC. And she mentioned that mediation would be a suitable complement to arbitration and litigation. So Mr. Sadasivan will tell us about the services offered by the SIMC that was established in November of 2014, and the unique, innovative arbitration service offering that the SIAC, the Singapore International Arbitration Center, and SIMC jointly developed to save parties time and costs.
Thanks, Yokui. I noticed that my two preceding speakers didn't have the opportunity to change the slides. So could I test whether the slides can be prompted for a change? Who actually changes the slides? Because I don't have a remote control here. Is there anyone over there who changes the slides? Okay, I guess. Is this one? How do you change it? Just press. Ah, it works. How do I bring it back? Sorry, how do I bring it back? Sorry? No? Sorry. Oh, this, the red one? Yeah. All right, thank you. Perhaps I just want to start by giving a little bit of a background to the difference between arbitration and mediation. Arbitration is enforceable and binding. Mediation is not, usually. That's a fundamental difference. In arbitration, you have a tribunal that awards a judgment. In mediation, it's a lot more difficult because the mediator has to be skillful enough to be able to bring the parties to come to an agreement on their own volition, right? So that's the difference between arbitration and mediation. Now, if you look at this particular set of slides, right, the extreme left, you see the difference in the growth in interest in mediation. It's 11% change over the years. The one in the middle is the difference in growth in arbitration. That's 3%. And on the right, you see the hybrid model where you use both mediation and arbitration, right? And in this case also, there's been 11% increase in interest. Now, this is in the Fortune 1000 companies, a survey that was done in 2003. Now, let me perhaps give you a little bit of background as to on how arbitration came about. Arbitration was introduced post-World War II. Now, what happened was there was rapid decolonization, and as a result of that, there was capital flow going from the colonial masters to the newly independent countries. Now, because the colonial masters who were driving the capital flows in didn't have that much faith in the judicial process of the new nations, they decided that there should be some independent and neutral and effective system. And that's where there was a demand for neutral, non-national adjudication of international disputes. Now, arbitration met this demand. Now, initially, arbitrators were non-lawyers and persons of integrity and deep understanding of commercial realities. And the arbitral decisions immediately post-World War II were based essentially on equity and practical needs instead of formal legal rules. Now, all this changed quite a bit in the 1970s, and there were two fundamental shifts that took place in the arbitration scene. One, the introduction of litigation-style procedures to regulate arbitral proceedings. Secondly, there was a clear tendency towards a more adversarial process, right? Now, in more recent years, with globalization, you'll see that together with the rise of the internet, there was a surge in commercial transactions across borders, right? M&As, mergers and acquisitions, surge in entrepreneurial activity, and transnational economic activity. Now, all this led to a commensurate increase in cross-border disputes, and these disputes have also become a lot more complex, requiring technical expertise in the people who are judging, right? Now, at the same time, there's also been, especially in the last 10 years, an increase in priority given by commercial entities on privacy, reputation, and relationships. And this has led to a growing interest in not only arbitration, but increasingly mediation. So, what is the strength of mediation? What accounts for the shift in, or the surge in interest in mediation? As you can see in the Fortune 1000 companies. 3 factors. Control. The parties involved in mediation have a lot more say on which aspects of the conflict they would like to focus on. Secondly, creativity. And in mediation, you use both legal and non-legal means and options to find a settlement. It's a more holistic approach. And thirdly, continuity. No one party needs to emerge the loser, and therefore there's a much better chance that commercial relationships have a chance of surviving, which is extremely important these days. Right? So mediation essentially preserves relationships. And in today's world, if you talk to most entrepreneurs, most captains of industry, this is an important consideration. Arbitration is binding. Therefore, mediation and arbitration combined is a potent combination, right? So, if you look at India, the mediation, since when did mediation become a lot more accepted? I think the concept was given official court recognition only in 1996, and also subsequently through the amendment of the Civil Procedure Code of 1999. And the turning point in the development of mediation in India was a result of the landmark decision by the Supreme Court in 2009 in a case of Salem Bar Association versus the Union of India, where the court held that reference to mediation, conciliation, and arbitration are mandatory for court matters. And subsequent to the establishment in India of the Delhi Mediation Center in 2005 and the Bangalore Mediation Center in 2007, approximately 31,000 cases, from what I've gathered, have been sent to mediation, have gone through mediation, and of this is interesting, 60% got settled in an average of 2 months. Now, what's interesting is, in 2013, according to 2013 statistics, the total number of open cases today in India, from the lowest courts to the Supreme Court, stands at 31 million. Now, so mediation and arbitration is a way to clear the backlog as fast as possible. Otherwise, it's going to be difficult, right? And the judges are increasingly aware and cognizant of it and resorting to it, right? So, and if you look at mediation, and as Shadul had highlighted just now, when you talk about mediation and arbitration, there's an increasing interest in looking at neutral institutional arbitration and institutional mediation, not so much ad hoc. And this is where it is interesting. There was an Ernst & Young study conducted last year, and it highlighted that the respondents, 74% of the respondents, would want an arbitration and mediation clause in their commercial contracts. Now, 60% did say that they would like institutional arbitration under the auspices of the Singapore International Arbitration Center. These are Indian commercial entities. So there's a certain interest and preference for neutrality and institutional arbitration. And thirdly, 78% of the respondents were satisfied with the arbitral award. Right. So I'd now like to highlight the SIAC, Singapore International Arbitration Center, and SIMC, Mediation Center protocol that we developed, called the ARP-MET-ARP protocol or service that the Senior Minister of State highlighted earlier this morning. So if you look at the slide, it shows that you start with arbitration. So an arbitral tribunal is convened, the case or the conflict is framed, and then you pause, and it is then sent down to mediation. And if there is a settlement, for it to be binding, it goes back to the arbitral tribunal that was convened earlier for it to become a consent award. And this consent award is recognized and accepted and enforceable in 156 countries, all of whom are signatories of the New York Convention of 1958, right? Now, it's a one-stop process under the auspices of the two organizations, the sister organizations in Singapore, SIAC and SIMC, and the savings for commercial entities would be cost, time, and reputation. Just to give you a sense, typically an arbitration could take from anything from 6 months, a year, to 2 years. Mediation can be as short as 1 day. My own experience in mediation, I've been a principal mediator with Singapore Mediation Center for 21 years now. And on average, a year, I have been mediating about 3 cases. And to date, there's only been 1 case that I've not been able to settle. So the settlement rate in mediation is significantly high. And my settlement rate is typical of most mediation cases in Singapore. So I'd leave you with that thought. Thank you very much for the opportunity.